Welcome to another episode of the hit podcast, MissTrial. I'm Karen Friedman Agnifilo, joined by my colleagues in crime, friends, business partners, whatever we are, Danya Perry and Kathleen Rice. We are three recovered government employees who are in the private sector and looking at all of the things that are going on at the intersection of law and politics and saying, hey, this is bananas. What is going on? And we thought we would come together and give you our perspective on all things so that we can understand and get the truth out there, since so much that is going on is misinformation and spin. And that is not what we do. What we do is we do our homework. We read things for ourselves so that you don't have to. We read court filings, court decisions, and we come here to tell you what they actually say so that you are fully armed at your dinner table with your relatives who might say other things, and you can know the truth. And so when we're giving opinion, we'll tell you that it's our opinion. When we tell you that it's fact, it is fact, and you can fact check us all you want. We are three former prosecutors, and Kathleen was also a member of Congress. And so honesty, ethics, integrity, it's in our DNA. It's what we grew up with. And that's what you're going to get from us is the truth, the unvarnished honesty and truth. So we're so thrilled. We have three huge topics again, even though it's the dog days of summer. Sometimes you wonder, what are we going to talk about? All the judges and courts typically go on vacation in August, and so much doesn't happen in August. It's when everything slows down, but nothing has slowed down for us. In fact, we had so many topics that we could have talked about, and we picked three so that we can the three that we thought were the most important ones, so that we can just kind of update everybody and let you know. We're going to start today with Manhattan DA's office. The sentencing is coming up soon, and we have to talk about that because the judge has issued a letter to the parties, and we're going to talk about what it says and what to expect and what he has said he would like from the parties and what he expects to happen September 18th. So I'm going to talk about that, since I used to work at the Manhattan DA's office for 30 years, if you can believe it. And then we're going to pivot over to, yes, the Washington, D.C. case is back. It is the United States Supreme Court issued the mandate we've been all waiting for and sent it back to Judge Chutkan in Washington, D.C. And it's time now to restart that case. It was on hold. Her jurisdiction was divested of her while it was on appeal, and they sent it back. So now she has jurisdiction over it again. And we're going to talk about that, and we're going to talk about what that means and what's going to happen. And we're going to, thankfully, we have our resident former federal prosecutor, Danya Perry, who's going to take us through that, since Kathleen and I were state prosecutors for many, many, many years. So Danya's going to talk about that. And then, of course, we need to, the most important thing of all is to decide who to vote for in November and to get out and vote. And so one of the things that we're going to talk about every week on MissTrial is Project 2025, because that is the MAGA platform. That is what you will be voting for if you vote for Donald Trump. And so that is their platform. They have made it very clear that that's what they intend to do. There's no secret. There's no mystery. There's actually a manifesto of what they plan on doing if Donald Trump gets into office. So the more we can keep you informed with that, the better. And Kathleen has picked another section. I think it's 900 pages. So each week we're going to pick another section for you and break it down. And Kathleen's going to take us through yet another section of Project 2025. So that's what we have on the calendar for today. We also thought it would be fun to get a little more interactive. So Send us questions, leave them in the comments. If you're watching this on YouTube, we love comments when you leave them, and we appreciate all of the thank yous and the, great job and all that kind of stuff that everybody's so kind and generous saying to us. But if you have any questions, or if there's a particular issue or area you want us to address, send it in the comments, and we'll see if we can also provide that for you on MissTrial. So we are here to inform you, and there's no one I'd rather do it with than my two friends, Danya and Kathleen. Hi, guys.
Hey, guys.
Good morning.
I think I need to get glasses. You guys look so bookish. I just realized there's something missing here. I'll try it.
Nah, I can't. Sometimes I keep the filings and things on my screen so I can refer to. First of all, I can't see you without glasses on the screen, but also I put all the things we're going to talk about. I put them on my screen so I can refer to them and quote from them, and I won't be able to read from them without glasses. Although the glare is terrible, and one of the things that people have been so generous with is sending me suggestions of other glasses to get, or a filter.
Karen?
Yeah, blue light glasses, a polarizing filter on the camera. So I actually ordered that filter. I'm going to try that next week, and I also ordered glasses. So we'll see if I can finally figure out. I don't know, Kathleen, you don't have the glare in yours, so I have to figure out.
I don't think these have that thing, but I guess I don't know. Yeah,
I don't know. Yeah, I have to figure that out. I mean, look at how bad it gets if I look straight. So I have to look down a little bit. All right. So do you want to just get started with Manhattan DA? Okay, just to catch everyone up of where we are, the Manhattan DA's office was supposed to submit and participate in the sentencing of Donald Trump in July, but I think it was July 11th, but on July 1st, the United States Supreme Court came down with their immunity decision in United States versus Trump, creating this new category of, frankly, get out of jail free card law of sweeping presidential immunity. It's actually caused a lot of members of Congress to consider passing legislation called I think we are not Kings Act or something like that, the No Kings Act or something like that, because it's really atrocious. It's this broad sweeping immunity that frankly, nobody in the country has other than the president of the United States. And that was not supposed to ever be that way. And so that decision came down, and the Judge Juan Merchan, postponed the sentence for September 18th in order to figure out whether or not that decision applies to the Manhattan DA case and any of the evidence there, right? Because although the paying off a porn star to suppress and then reimbursing your private attorney in order to suppress the information for the electorate, although that seems entirely personal and it's something for as a candidate, not as president, it's definitely the reason that the decision applies to it, even though it's not presidential acts, is because one of the things the decision did was it encompassed evidence, right? Not just acts, but evidence to prove or disprove that something is presidential or a core function or within the job description of president and therefore would fall into the immunity category. You're not even allowed to talk about or introduce evidence that could be privileged. So the decision went way further than even the parties asked for it during oral arguments or in their papers. It was actually shocking how far that decision went. And all you have to do is read Judge Sonia Sotomayor's dissent in that case. It is brilliant, and it actually captures why this is such a dangerous and unprecedented and just bananas decision, giving the president the sweeping presidential immunity. But Judge Merchan had to consider it and frankly run the facts of that case through the filter that case created, in order to see what applies and what doesn't apply. So it wasn't surprising that he would adjourn the sentencing. There was one sentence, though, in his decision to postpone that I think gave everybody a little bit of pause and worry when he said he put it over till September 18th for sentencing if necessary. Everyone's like, wait a minute, what do you mean if necessary? But he was keeping his options open in case he ruled that the case should be dismissed given this immunity decision. So that made a lot of sense, but it was a little scary. I wish he hadn't put that one little sentence in there. But he came out with a letter to the parties on August 5th. He sent it to both attorneys and said basically, dear counsel, as you are aware, attorney for Mr. Trump filed a pre-motion letter July 1st seeking leave to file a motion to set aside the jury's verdict. So he's just basically saying, this is where we are, kind of what I just said, right? That Trump filed a motion saying set aside the verdict based on the Trump case, the immunity case, and I set certain deadlines and we rescheduled things to September 18th. He says then after that, the defendant requested even more time to file more paperwork to respond to the government because of changed circumstances due to recusal. So what does that mean? That means Trump is once again filing papers, trying to get Judge Merchan recused from the case. I have lost track of the number of recusal motions that Trump has made about Judge Merchan, and it's been denied over and over again. And one of them in particular, Judge Merchan, it's based on his daughter his adult daughter who works for a consultant company that supports Democrats, I think, political consultancy, but she's an adult. She works on her own. And there were two small, like they got $10 and a $15 donation, political donation that Judge Merchan made to Hillary Clinton when she was running against Donald Trump, and to another Democratic like Vote Blue or something organization. And those small, minuscule donations, Trump says, disqualifies him and he should be recused. So what Judge Merchan did is he sought an advisory opinion from the judicial ethics oversight that governs New York State judges. And they gave an advisory opinion that basically said, you don't have to recuse yourself. And it's entirely up to the judge, by the way. It's discretionary whether he wants to recuse himself or not. And he already gave a lengthy decision as to why he does not need to recuse himself from this case. So what does Trump want to do? He files yet another recusal motion in the middle of all of this. The prosecution replied, and they want even more time to file more papers about this. And the judge says, no, I'm sorry, I don't need you to do that. I have all the information I need. And so, but once again, he's asking for delay because that's what Trump does. Delay. And he wants delay for the recusal motion. He wants delay for this immunity decision. But what Judge Merchan said was, please note, the court appearance scheduled for September 18th at 10 a.m. remains unchanged. We will proceed on that date and time to the imposition of sentence or other proceedings as appropriate. Please keep these dates in mind. If you still wish to file a pre-sentence recommendation is not mandatory. You don't have to file one. You can just give your recommendation orally, which some lawyers do. But in big, important cases, I would be shocked if both sides did not file a pre-sentence recommendation. And that's the time that Trump will put in there all the reasons why he thinks he should be given leniency. And normally what would happen is a defense attorney would do things like submit letters from the community saying things like, my client is a good guy, and please be lenient. Please don't do anything to him and sentence him and that sort of thing. And he's sorry, and he's given money to charity, and he's done all these things, and this is out of character. I mean, those are the things that are normally in a sentencing memo. God only knows what will be in this one, given the fact that Trump has never showed any contrition has never taken any responsibility for these actions, still thinks he's the victim, blames everybody, political persecution, who knows? I can't imagine what he would put in a sentencing memo. And then the prosecution will submit one saying all the reasons why he should get whatever it is they are recommending that they give him. And then the judge asks people, he gives everyone an opportunity to speak during sentence. And then the judge speaks and issues a sentence. So that's what will happen on the 18th. I would imagine, given the appellate issues in this case, especially primarily the presidential immunity one, I would imagine that the judge, if he sentences Trump to jail, that he would press pause on that and not make him go to jail during the pendency of the appeal, especially because there's an election happening, and that would be considered disruptive of the election. So I don't expect the Trump to have to bring his toothbrush on September 18th, which is what we tell our clients who may go to jail. But I do think that sentencing will go forward, and that's what we are. I mean, that's like tomorrow practically, right? Summer goes by so quickly, then comes Labor Day, and all of a sudden here we are, September 18th for sentence. So that's right around the corner. So that's why we wanted to just kind of bring that back to the forefront for everybody. So anyway, that's what's going on in New York. Before we segue over to Washington, one of the things I wanted to also remind everybody is Danya is going to talk about the Washington, D.C. case and what will happen there in order to determine presidential immunity question and the filter that they have to put those facts through. There's no need for a hearing, an evidentiary hearing in the Manhattan case, because there was a trial already. So the evidence is out there. The witnesses all testified. All the evidence is there, and they were cross-examined. So there's a full record that the judge can look at to determine what falls in the bucket of immune or not immune. And so it'll be interesting to see what he rules. I remain concerned about one small aspect of the trial, which might not be so small, but during summation, Josh Steinglass talked about your client, Danya, Michael Cohen. And, if you think he has credibility issues, you don't have to only rely on him. There's all this corroboration. And he really focused on one piece of evidence, which was the Hope Hicks testimony, talking about how when Trump said to Hope Hicks, it was April of 2017. She was a White House employee at the time. He was president, and they were talking about White House things and, presidential issues. And then they were talking about the fact that the Stormy Daniels case, the Stormy Daniels story came out, and Trump said to her, good thing it didn't come out before the election. And that was really, really powerful. She broke down crying in court when she said that. I was actually there in court, and it was stunning. It was like the closest thing to a Perry Mason moment, because it was like she realized, oh my God, I just sank him. Because one of the elements of the crime is, that this was the reason he did this wasn't to protect Melania. The reason he did it was to influence the election. And so that was the nail in the coffin, frankly, that this was all about the election. And it's like she realized the gravity of what she had just done, and she broke down into tears. And sure enough, the prosecutor agreed with my assessment, and I'm sure everyone else in the courtroom's assessment, and really leaned into that in summation and said, rely on that. And that's problematic, because the judge is going to have to do it. Is this, yes, some of these pieces of evidence are fall within the immunity category, but is it harmless error? And so therefore it doesn't matter, and it doesn't disrupt the trial. This is the one piece of evidence that worries me a little bit. And so because the prosecutor asked the jury to rely on it so much. So we'll see what the judge does. But I don't know. Do you guys have any thoughts on this before we pivot?
Well, on that, I do agree. I mean, he'll have to do a harmless error analysis, but only if he first finds that that conversation was, within that outer perimeter. It was not clearly, whatever he was doing was not an Article 2 official act, him speaking with someone in communications in the White House, right? That's not exclusively within the president's authority. So, but is it in that outer perimeter? The judge will have to decide that. And then, if he finds that it was, and is potentially immune, is the government able to kind of rebut that presumption? And then, if he finds those things, I mean, he could have been talking to her you were in the courtroom, I wasn't there that day, but, talking to her in a personal, as a personal matter, rather than in any official capacity of, hey, here's how I want you to message this issue to the American people. So that's the obviously the first piece of the analysis. And then if and only if he finds that this was an official act and is entitled to immunity, then he'll have to decide if it was, if it harmless error. And I agree that, the fact that it was such a, an aha moment where, gasps, came out of the courtroom wells, and the government prosecutor in summation did refer to it as devastating. So, but there was such a mountain of evidence, as Steinglass also said, and as anyone sitting in that courtroom heard for themselves, and the judge as well. So it could be that it's just, a grain of sand on the beach at the end of the day, and not kind of a dispositive piece of evidence. But I agree with you, Karen. Certainly, I think that's probably the greatest area of vulnerability for the prosecution there.
Well, I think it also just points to how ridiculous this whole idea of official and non-official acts are. I mean, in any given day, in any given hour, how many official and non-official things are you doing? You know what I mean? It's like, I don't know.
Yeah.
It's just a crazy one.
Yeah. Well, look, I mean, the courts are going to have to, several courts, are going to have to do this analysis of what is and is not official. There's not a lot to go by, obviously. And so, Judge Shutkin will start to do that analysis, and, Judge Merchan also will have to some degree. It's coming up in other ways. Jeffrey Clark, right, who was in disciplinary proceedings in the District of Columbia, and a recommendation was made actually to sanction him. And he's now coming out and saying, well, wait a minute, the conversations I had with the president and the letter that I drafted to go down to the Georgia legislature, that was in furtherance of the president's official act. And so I should not face disciplinary proceedings as a result of that. So that's going to go in front of, the board there, the grievance board. And then that could, that will be appealed, and, the courts could. So all kinds of determinations are going to have to be made. And I think, that argument just points to how sweeping and broad and potentially limitless, that official duties, are that are entitled to immunity. And lines are going to have to start to be drawn hopefully by reasonable courts.
Well, really quick, just to remind people, Danya, who don't have this memorized like we do, Jeffrey Clark was the environmental lawyer at the Department of Justice, who kind of far down the pecking order of attorney general, assistant attorney generals, and even in the civil environmental decision or division, and nothing to do with criminal. He's the one that Donald Trump was thinking of appointing interim attorney general after he lost the election, days before the Jan 6, right? Taking over, trying to make him attorney general so he could, because he was willing to say that there was fraud, and to further investigate whether or not there was fraud. And there was testimony before the Jan 6 committee that the entirety of the Department of Justice would resign if you appointed him to be attorney general. I mean, it was just crazy, and now he's indicted and an unindicted co-conspirator, and so he's in trouble. But that was the Jeffrey Clark, just to remind everybody who he is. But yes, now segue into Judge Chutkan.
It would also let us segue to the Project 2025, because and so we can put a pin on that. But because, as you were just saying, Karen, the reason why he was, Trump was not able to appoint him is because there would have been, a massive resignation by stalwarts at the Department of Justice who wanted to uphold the rule of law and said no and put their foot down. And if Trump is reelected and Project 2025 becomes the transition plan, and then the 100-day plan or 200-day plan, if that is implemented, then the Department of Justice loses any semblance of independence, and there aren't going to be people like that who stand up and say no, like Richard Donahue did, and Jeff Rosen and others who were in the department and said no. So we'll put that little pin in there, and Kathleen can pick it back up. But let's take the opportunity to start talking a little bit about what is going on in the DC court now that the case has finally been remanded to Judge Chutkan, who, as you said, did not have jurisdiction from the fall until last Friday, August 2nd, where she got the case back and hit the ground running, immediately issued an order saying that she would like the parties to submit a status report with the, what they view as the next steps and the schedule for the next steps. And then she is going to hold a conference next Friday, the 16th, 10 in the morning. So we may have to do a special episode after that, because I think that will be, shed a lot of light on what she's thinking in terms of next steps, and perhaps this evidentiary hearing that you alluded to, Karen, that will help her determine what is and what is not an official act for the purpose of deciding whether immunity applies or not. She hit the ground on that. She also clearly had not just hung it all up while the Supreme Court was taking their sweet time. She the very next day, on August 3rd, she had an opinion read and published. That related to a motion to dismiss that had been fully briefed way back when, before she temporarily lost jurisdiction. And that related to the former president's arguments that he had been both selectively and vindictively prosecuted by this Department of Justice and by the special counsel, Jack Smith. And she quickly laid waste to those arguments. Like, it's just worth unpacking it a little bit. And because I think it sheds light on what the Trump strategy is, but also gives some insight into the way Judge Chutkan is thinking about these matters, perhaps the way she will, although she of course will wait to get all the data, but kind of her mindset going into the briefing and the hearing, perhaps, on the immunity issue. So what Trump had argued is that the case should be dismissed because he was unfairly prosecuted. And they're two kind of separate, although oftentimes overlapping theories. The first is that he was selectively prosecuted, which he would have had to make a showing that he was kind of singled out, that comparators, that people like him in the same position as him, basically indistinguishable from him, were not prosecuted, but he was, and that he was prosecuted for discriminatory reasons and with discriminatory intent. And there, Judge Chutkan blasted that theory, but she took the opportunity to say that to really take Trump and his lawyers to task for the way that they had framed the arguments and really the allegations in the indictment. And she said, no, Trump, you've improperly framed the allegations, and said that the way that Trump had framed the indictment was saying that it amounted only to a government, as the quote, theory that it is illegal to dispute the outcome of an election and work with others to propose alternate electors. And she says, no, that mischaracterizes the alleged conduct here. That here he had been charged, and she said this really firmly and right out of the gates, that no, Trump had been charged with knowingly making false statements in furtherance of criminal conspiracies and to obstruct the election certification proceedings. That is not, merely and innocently publicly disputing the election outcome. That is not what he did in this case, as alleged in the indictment. And then she went right on to say that his argument that others who were similarly situated have not been charged is not accurate. That that she has already explained that the defendant is not being prosecuted for just contesting the results of an election, right? That, of course, would be free speech, and many people have done that at many times, in the past. And the reason they're not charged because that's not a criminal act, but as framed in the indictment, the conduct here is a very different story. And so she quickly rebutted that and knocked it down. The indictment actually went to pains to say he had every right to say he didn't like the results or to even to dispute them in court. Like, every American has the right to do that. And so the indictment goes to great lengths to kind of separate out what is lawful and free speech from what is not, which is these schemes, right, to to pressure Pence and to bring in a fake slate of electors, also to use the Department of Justice, obviously, to to weaponize the Department of Justice. Now that we do know from the Supreme Court's opinion, that is out because they found that immunity applies because that's a core function of the presidency. But they are very clear about what is and is not fair and lawful conduct. And so Trump's parsing of it, the judge had no trouble handily throwing that out and saying no. And then the defendant had cited several sources, public statements by President Biden to say this shows discriminatory animus and intent, and she said not at all. And for that, I won't belabor it, but it doesn't even begin to show that Biden was behind this and that he was trying to go after the former president. That's just not even close to what those cherry picked statements show. And in fact, Biden has gone to great pains and great lengths to stay out of this. And the very articles that Trump cites actually say that as well. So that was not hard for him, for the Judge Chutkan to deny and reject. And the second and somewhat related argument that he made was that he was vindictively prosecuted. And there, really what a defendant has to show is that he was just minding his own business and asserting his rights, to make arguments, and that it was because he was exercising his legal rights that he was prosecuted. And I don't think, the judge doesn't take too long to shoot that down, because it's obviously not what Trump was doing. He was not just, merely exercising his rights. The kind of cases that usually, it's a hard bar to clear. The kinds of cases that win, right, where the judge will say, okay, I see vindictive prosecution. The typical case there is where a defendant makes some arguments in court, and some of them are accepted by the court, and so some charges might be knocked out, or they win on appeal, and then when the prosecution gets the case back, they add extra charges, or they double down, right, or they up the ante with what sentencing exposure might be. That take some action that they would not have had not previously, and did only in response to, the defendant winning some kind of motion and exercising, their due process rights to question the charges. That's not this. So that, kind of takes us back to what the real task at hand for Judge Chutkan is going to be, which is going to be to apply the Supreme Court's immunity rule to the allegations in the complaint. And, just to review quickly, Supreme Court created, really, right, for the first time ever, created 3 categories. The first is absolute immunity, where the president has exercised his core constitutional authority, right? And that, it's what's in Section 2 of the Constitution. It's things like vetoing, a law, or appointing an ambassador. Those kinds of things are right out there. They're laid out. They're core constitutional functions that only the president, the chief executive, can exercise. So those are pretty clear. The Supreme Court said that Trump pressing the Department of Justice, those allegations are out. So even though the allegations were he was pressing them to bring, fake cases, or to send, a letter to the Georgia legislature that would have made fake, and false statements, they're saying that has to come out, that he cannot be charged for that, and no evidence about that can come in. So that was category 1. Category 2, we referenced before, but presumptive immunity. That's where kind of in the outer perimeter of his official acts. So it's really everything else. That's an official act, even though it's not of constitutional magnitude. And then the third category are purely personal acts, not official acts, private, unofficial acts. That immunity is, the president is not entitled to immunity for those acts. And so now she's going to have, 2 threshold tasks in front of her, is separating out official acts from unofficial acts. And then of the official acts, separating out what are core constitutional functions from those that are not, that are official in some way, but not core constitutional, and then have to decide from there, whether immunity attaches or not. And so, there are some things, as I said, the Supreme Court has already said, Trump pressing the Department of Justice, that is official. You can't go there. There was an interesting colloquy, discussion between Justice Amy Coney Barrett and Trump's lawyer in oral argument. And Trump's lawyer, Sauer, made some concessions, basically about some things that were not official and that presumably then could come in. But Judge Chutkan will obviously have to do her own analysis. Those things included, and I'm reading from it directly, but Barrett says, so petitioner turned to a private attorney who was willing to spread knowingly false claims of election fraud to spearhead his challenges to the election result. Private, she asked him, and Sauer conceded, that sounds private to me. So there are a couple of those. We could go into them if you guys think it's good use of our time. But he did make some concessions where it involved private actors, right, conspiring essentially to say cause the filing of a verification signed by petitioner that were false. That Sauer again said that also sounds private. So it's going to be, she's really going to have to parse the allegations in the indictment and bucket them, in the way that the Supreme Court has now said that they have to be. And so there are going to be some interesting ones, like pressuring Pence. Was that official or not official? Pressuring state officials, putting in the false slate of electors, and public statements that he made. Are they official or not official? I think here amongst the 3 of us probably have strong views that this stuff seems pretty personal, right? They relate to Trump as candidate, not Trump doing anything official as president. But that's, well, who are we to say? And this is brand new law here that Judge Chuckin is going to be making, and obviously, reflexively, is going to be appealed to the Supreme Court. Will get to tell us what is and is not public. So obviously, we have to stay tuned for that, and that can take long.
I think that the government, through the special counsel's office, is going to concede that certain things are official, right? They're going to have to, that certain things come out. I don't think Trump, on the other hand, will. I think they're going to change their tune about what John Sauer said during all our arguments, and they'll figure out a way to. They're not going to concede anything. They're going to say the whole case comes out. But I have a logistical question for you, Danya. So let's say the judge. Let's just assume certain evidence and certain counts even might come out, but at least certain evidence is going to come out, if not the counts. What happens next? Does Jack Smith have to supersede the indictment, or how does that work logistically?
I think it will depend on what she rules. Really, he can just take some of it out. He can redact it, just take it out, and not, he does not. He would not have to go back to a grand jury. I'm positive that same grand jury is not sitting. So if there is something, if he needs to actually recharge something in the actual claim, it's a speaking indictment, right? Which means there's a lot of background, and he lays out in great detail the way, government and the grand jury sees the allegation. So that stuff can just be redacted. If the charges themselves have to be changed, we might have to go back to a new grand jury and represent all the evidence. So I think it really remains to be seen based on how she slices and dices it. Yeah. So it could be a whole to do, but regardless, it's going to be something will go forward, right? That's I guess the good news.
What's the date? When is this happening again?
So it's next Friday will be a conference with the parties where she will have taken into account the parties' views about when, the way things should proceed and under what timetable. I think we can imagine that Jack Smith will say immediately, and that Trump's lawyers will say never after the election, certainly. And so she will decide for herself what the schedule is going to be. So we'll know a lot more then about how she's viewing it and what, whether she will have this evidentiary hearing and when. And if she does, there's no reason why it wouldn't happen quickly, as soon as, both sides will have obviously the opportunity to present evidence and including witnesses. We talked in a previous episode about how something like this happened in the Georgia election fraud case, where Mark Meadows was seeking to remove it to federal court, and because he was saying his acts were official, and the judge there had a hearing, and Mark Meadows himself testified. And so, while I doubt Donald Trump will testify here, certainly you can see some important figures who are, who provided testimony that, formed the basis of these charges. They could very well be testifying and cross-examined and redirected. So, it could be a little mini trial.
I wonder who has the burden. Is it going to be the government to prove that it's not immune, or the defendant that he is?
Well, it's, the Supreme Court has said, look, Judge Chuckin will have to say if something was a core constitutional act, right? I think that will be a question of law. I don't know if there's going to be evidentiary hearing, right? That's not a fact-finding thing necessarily, but that broad middle category of acts or conduct that could be official but is not core constitutional, where the Supreme Court said there's a presumption of immunity there. That I think the government, will have to rebut that presumption. And so the burden will be on them to say, no, these were not official acts and immunity does not apply. So really going to be novel. Everything is brand new, right? There's a new rule, new substantive rule, and then new evidentiary rule that the Supreme Court has just announced. So we're in uncharted territory here. But Judge Chutkin has proven herself to be incredibly able jurist, very sharp and very careful, and is gonna, cross all her T's and dot all her I's. So it's she's going to be figuring this out for the first time herself.
I'd imagine that Trump does not want an evidentiary hearing because it is like a mini trial, as you said, and he doesn't want all that out there. But if I were her, I'd say, look, the Supreme Court wagged its finger at me saying I didn't bother to make a fact finding below. And so, here we go. So they gave her permission, I guess, to do it. So I suspect she's going to do it exactly as you predicted. All right, we got to go to an ad break. We have an ad, which is one ad break today for a pro-democracy sponsor that we're thrilled to have for MissTrial. So let's go to a quick ad break. Don't go anywhere. We'll be right back. It's a quick one. Let's face it, after a night having too many drinks, I don't bounce back the way I used to, for sure. So I either have to make a choice. I can either have fun with my friends or have a good next day. That is until I found Z-Biotics. This is a probiotic invented by PhD scientists to tackle rough mornings after drinking. I don't want to look puffy. I'm on TV all the time, or I'm doing a podcast. There's no reason to have that puffy feeling or those puffy eyes. So here's how it works. When you drink alcohol, it gets converted into a toxic byproduct in the gut. And this byproduct is not dehydration. That's not the only thing that's to blame for your rough next day. Pre-alcohol produces an enzyme to break this byproduct down. And so this is a proactive solution that wards off feeling miserable the next day instead of a reactive approach like drinking electrolytes or eating greasy food, also something I don't like to do anymore. So every time I have Z-Biotics before I drink, I notice a difference the next day. Even after a night out, I can confidently plan on being able to appear on television without worry. So admittedly, I was a little skeptical at first, but then when I was hanging out with a friend and having a couple glasses of wine, I gave it a shot. But now that I've tried it a few times, I know it works. And so I absolutely love Z-Biotics. And it's something that I will use if I'm going out to dinner, having a couple glasses of wine. So depends on whether you're on vacation, or shouldn't depend on whether you're on vacation, going to a wedding, birthday party, reunion, dinner, like me, anything. Get the most out of your evenings out and join the movement of people like me who are choosing Z-Biotics for smoother mornings and unstoppable success. So enhance your mornings with Z-Biotics. Go to zbiotics.com/misstrial to get 15% off your first order when you use MissTrial at checkout. That's with 2 S's, by the way, MISS trial, no space. Z-Biotics is backed with a 100% money back guarantee. If you're not satisfied for any reason, they'll just refund your money, no questions asked. So remember to head to zbiotics.com/MISSTRIAL and use the code MissTrial at checkout for 15% off. Thank you so much, Z-Biotics, for sponsoring this episode. Okay, we're back, and we love our sponsors. So this is awesome. Please support our pro-democracy sponsors. They know what the show's about, and they choose to advertise on this platform. And so we want to show your support for them. Plus, they have great products. We try them all out, and we endorse them as well. Otherwise, we wouldn't be having them on our show. At least I do. So, anything else on the Chutkin, Washington D.C. Thing that anything you want to add, Kathleen, before we move over to why it's so important to vote in Project 2025?
Well, I mean, if this hearing happens, it's going to be incredibly important, and I hope people watch it because, to your point,
Can't
Danya,
watch. They can't watch. They can follow. Yeah, crazy federal court.
Well, they should. People should be able to see this kind of
Yeah.
stuff when democracy is on the line.
Yeah.
But this is why I love doing what we're doing right now with you ladies, because there are so many places where people can get their news. Some of it is not true news. And we just give the facts. We give the law and the facts, and sometimes that intersects with politics. And what I have always, had my name on a ballot, I have always been a supporter of voters having more information than less information about the people that they are asked to vote for. So that's what this is all about. And, I'm going to just talk about, another section of Project 2025, which again, as Danya mentioned last week, is a 922-page policy blueprint that was created by the Heritage Foundation. Just a little background about them. It was created back in 1973. It's a nonprofit public policy research institute that is backed by very prominent conservative names that people will recognize, like Koch and DeVos. And what they do is they create these conservative manifestos for Republican presidents. And the first one they did was in 1980. And Ronald Reagan adopted a lot of what was in the blueprint that they created back then. 2025 is no different. It's meant to be a blueprint for a Republican president to implement. Donald Trump has repeatedly tried to distance himself from Project 2025, saying he doesn't know anything about it. But I don't know if you guys saw this, but Kevin Roberts recently, who's the president of the foundation, recently confirmed that he, quote unquote, personally discussed Project 2025 with Trump, very likely on a private flight that Trump had with Roberts back in April of 2022. Again, Trump's campaign totally trying to distance him. And the reason why, in my opinion, is because a recent polling showed that 63% of Americans support having abortion rights be legal in this country. 63%. I mean, it's just an amazingly high number. And Trump sees those and understands that he does not want to alienate a lot of who those voters are. So let me just give you some numbers here. Since Dobbs came down, I'm just going to give you some numbers. There are 13 states in the country with a total abortion ban. 13. There are 8 states that have severe restrictions on abortion. There are 9 states with proposed ballot measures to protect or expand abortion rights. There are 13 states with efforts underway to put constitutional amendments regarding abortion on the 2024 ballot. And since Dobbs was decided, 6 states, California, Kansas, Kentucky, Michigan, Vermont, and Ohio, have voted on abortion-related constitutional amendments, and the side favoring access to abortion prevailed in every single one of those states. So that is the trend. And so let's just go try to dive right into the abortion section of Project 2025. The author of this section is someone who was served as the attorney. He's an attorney who served as the director of the Office of Civil Rights in HHS during Trump's first administration. His name is Roger Severino, and he authored this. So it reads, and I'm going to read the exact language.
Which also, by the way, flies in the face of Trump saying, "Oh, I don't know these people. I don't know anything about it." This was one of his people in his.
He's a fellow at the Heritage Foundation, and a lot of ex-Trump administration members are authors of this manifesto. So, I mean, it's becoming more and more
analysis, and they found that there was overlap with Trump and this manifesto of 240 people. It's like
Yeah.
huge number of people,
You can't-
including people who were in the first administration and who absolutely will be in the second.
There is no question about it. And remember, back in 2020, I think most people were surprised that Trump won, mostly Trump himself. He didn't have anyone, he wasn't vetting anyone for any positions. And he, in large part, took recommendations from because another part of what the Heritage Foundation does is they make recommendations for high-level administration officials for Republican presidents to choose from. And Trump referred to their suggestions in many occasions when he was trying to fill his first administration. So what Project 2025 says is the Dobbs decision is just the beginning. Conservatives in the states and in Washington, including the next conservative administration, should push as hard as possible to protect the unborn in every jurisdiction in America. So first, they're going to take aim at abortion pills. They indicate that fetuses should have legal rights and seek to expand surveillance. The word is frightening to me. Surveillance of abortion while eliminating government support for the procedure. So basically, abortion is not healthcare and should never be treated as such, according to Project 2025. By the way, they want to change the name of the Department of Health and Human Services to the Department of Life. That's another thing that Project 2025 wants to do. They also, there are, so many problematic things in this section, but first and foremost.
Department of Life?
Yeah.
Jesus Christ.
Yeah.
It's like,
Department of Life.
This is The Handmaid's Tale. I can't even, that's why this is so. And that's why this is so important that we talk about this and we dive into this every week, because I don't think people realize, this is shocking, Kathleen.
It's incredible.
Surveillance. They've talked in the past about monitoring women's cycles. Here it's, it is, they want names, right? They want to force states to give the federal government names of women who are seeking care, their doctors.
Yes. And Danya, further on that is, and if you don't give us that information, we're taking federal funding away from the individual states. It's just outrageous. Could you imagine if we tried to get medical information about men like that? It's just outrageous. And I think, again, this issue is so prominent because we have a woman running for president again who supports abortion access for women on the federal level. And there could not, the difference between these two, Trump can try and run away from Dobbs all he wants, but he put those three conservative justices on the Supreme Court, and then Roe v. Wade was overturned, period.
Yeah.
So,
Sorry, the mifepristone total ban, right? They're going to use the Comstock Act, right? Forget what year, 1870s or something. Right?
Ridiculous law that prohibits drugs, medicine, or instruments used in abortions from being sent through the mail. So they're going to.
What's the Comstock? We have to explain what the Comstock Act is.
Basically, it's a law that was passed in 1873, and it prohibits the dissemination of drugs, medicine, or instruments used in abortion from being sent through the mail. And mifepristone, as we all know, is a abortion medication sent through the mail. The volume. So now that the Supreme Court has overturned Roe v. Wade, this volume of Project 2025 states that the Justice Department in the next conservative administration should therefore announce its intent to enforce federal law against providers and distributors of such pills. So, it's just absolutely ridiculous. It also recommends the next Secretary of the Health and Human Services that they get rid of the Reproductive Health Care Access Task Force, which was established by the Biden administration before Roe's reversal. And in its place, they want to create a pro-life task force to ensure that all of the department's divisions seek to use their authority to promote the life and health of women and their unborn children. Just a couple more things to point out. This section also has a family agenda, and the proposal recommends the Health and Human Services chief proudly state that men and women are biological realities and that married men and women are the ideal natural family structure because all children have a right to be raised by the men and women who conceive them. Another program within the Health and Human Services Department should maintain a biblically based social science reinforced definition of marriage and family. So, I mean, I'm almost breathless at this point. And by the way, I grew up in a religious household. Okay, it's not about what your religion is. It is frightening that this kind of language is being placed in our laws that are being primarily imposed on women. But, Danya, you talked before about mifepristone. I think it's important to talk about the case that came before the Supreme Court by the Alliance for Hippocratic Medicine, a bunch of doctors who wanted, the plaintiffs were anti-abortion physicians and a medical association that wanted the Supreme Court to say that they could no more mifepristone. And the Supreme Court didn't get to the substance of it because they said that the plaintiffs couldn't show concrete injury caused by the FDA's approval of mifepristone. And so there is still a possibility that case will go back to the Supreme Court with plaintiffs who will be found to have standing, which is a frightening thing. But the reason why this is so important, this manifesto, is because the FDA approved mifepristone to be sent through the mail as a medical procedure that women are legally allowed to have. HHS oversees the FDA. The HHS is going to be it's a political appointment. And if the FDA, who is a bunch of just like lifelong, bureaucrats who just kind of do what they do, whoever is the secretary of HHS can say no more. And so it does matter. There's another case that I think, is, I don't know if we talked about it, you guys, but it was an Idaho case that the Supreme Court said that they would take. It was a case involving EMTALA, which is the Emergency Medical Treatment and Labor Act of 1986, which says that it guarantees patients the right in ERs to access to emergency medical services, including abortion, for their health and to protect their health. Now, the Supreme Court took the case and then admitted that it should not have taken the case before the Ninth Circuit's appeal process. So they returned. This case is now back in the Ninth Circuit for arguments. But this conflict between EMTALA and state abortion bans is going to come back before the Supreme Court. So between a conservative Supreme Court who is making decisions like Dobbs and other cases, since they have been seated, and this manifesto of the Heritage Foundation. I mean, if this is not enough to get people out to vote, I just don't know what is. I mean, individual states are doing the best that they can. But, if people don't vote, you don't have a say. And so I think it's really important that people, this is why us going through these different sections of what this plan is. And Trump can sit here and say that he doesn't know anything about Project 2025, but that if he wins, this is going to be the blueprint with which he, operates for the 4 years. Well, yeah, because those are the people he's going to appoint into positions. And, he shouldn't be able to get away with saying, I don't know anything about Project 2025. Read it. Yes. See what it is, and then disavow it.
Then he says on one side of his mouth, he says he doesn't know what it's about. On the other side, he's like, some of the things I like and some I don't. Well, really? How do you know that? He's never read a 922-page book in his life, like probably in the aggregate. But you look at he doesn't have an agenda. Look at what they put out. It's just like block letter, all caps, like it's nothing. It's not a real plan. This is the plan. And they're telling us. So we do have to take that seriously and act on it.
Yes. And listen, not only the thing about this choice that people have in 2024 is, yes, do we know how Kamala Harris would be as president? No, because she's never been president. We do know how Trump will be as president because we've seen it. This would be Act Two. And with all of this immunity issue and all of those things that the Supreme Court is ultimately going to end up deciding, the amount of power that Trump could have if he wins is unprecedented and frightening to even think about. And by the way, let me say, any president to have such immunity like that with little to no oversight is frightening.
Yeah.
So
It's
people
true.
need to vote, vote, vote. I don't care who you vote for, just vote. It's important. I mean,
Yeah,
I know
it is.
but it's important. It's important to vote.
And you know what you point out, Kathleen, women in particular, this section. I mean, you were reading that, and I thought to myself, are we going to have to start calling Trump commander? You know, I mean, seriously, this really feels like
Look, you guys are,
Handmaid's Tale.
it truly is. And, you know, both of you have daughters. I do not have daughters, but I have two great nieces who were just born. My namesake, Margot Kathleen, who is 6 months old, and Grace Christine, who was 1 month old. And I was with them 2 weeks ago. I get emotional just thinking about this and looking at them and saying, what kind of world, what kind of rights are they going to have? They're just babies now. What kind of rights are they going to have? And if you look at this manifesto, the answer is not many. Because if they're going for all of this, what's next?
I think about that, and I think about all the people I know who've had to make the gut-wrenching decision to terminate a pregnancy because they, you know, there's a ultrasound that shows that the baby, you know, has severe encephalitis and is going to suffer and die right upon birth. I, you know, have somebody who I know very close who that happened to, or, you know, it's a gut wrenching decision. It's horrendous, and so many doctors will say, you know, I can't do it, or I'm not going to do it, or I'm not going to put my life on the line, you know, and just what it's going to mean to them. And to future people who have to make that decision, right? You know, it's just having such a spillover effect into healthcare access, and it's just terrifying to think this is the world they want people to live in, and anyone who's had to make that decision or be faced with that choice. I'm sure is saying to themselves, thank God I was able to make that choice for myself. It's a personal decision between a woman and her doctor about whether or not to terminate a pregnancy for any number of reasons. And it is not something that anyone takes lightly. I don't know anyone who's used abortion as a form of birth control. I don't know anyone who chooses to do it, you know, in the 9th month, the way the fear mongers, you know, say, you know, it's just that the fear mongering is horrendous. And when you talk to people and you know people who've gone through this themselves, it's just terrifying to think that they're not going to be able to do this.
That's the specifics of that Idaho case. While that ban was in place, where they said the abortion law in Idaho superseded EMTALA, women had to be airlifted out of the state to get life-saving care. I mean, that's just outrageous. And the other part of Project 2025 that I wanted to mention as well is no more, you know, they won't allow any organization to counsel women about abortion possibilities. They want to instead have them talk about the family structure of, like, you know, figuring out how to do birth control by counting your cycle. I mean, this kind of crazy stuff that is just outrageous. And I just, you know, I hope that people, you know, really, if you are interested in learning more about it, read the project, read on, more about it. It's really important that you understand what is going to be implemented if, you know, Trump gets a second term.
The choice could not be more stark. On the one hand, our first female president, and then the other, you know, the guy who scoffs at her for being female because he doesn't think she's the DEI candidate. She's nasty, crazy, you know, because she's a woman. And that's it. Just couldn't be more clear.
Sure. You're right.
Yeah.
Right.
Right. Well, thoroughly terrifying.
On that note, I know. No, but it's, you know what? As terrifying as it is, we have to do it. You know, we have to do it because it's important. And I'm convinced we are going to have our first woman president, and it's going to be Kamala Harris. And I love her so much. And it's an exciting time. And so the more we can help that effort through shining a bright light on what Trump is doing, I think the better. So I'm thrilled to do it with the two of you. And each week that we take time out of our busy schedules to do this, it's always great to see you. I enjoy it thoroughly. But I also feel as a former recovering public servant, I do feel like I'm continuing on with public service by doing this for people, because not everyone has time to dive in and read all of these things and understand them and digest them. So to the extent that we can do this and do it together for people, I think it's an important thing. And we appreciate everyone coming here each week and listening, and all the feedback, and send in your questions if you have any, because we would love to answer them in case there's something you want us to talk about that we're not. So great to see you guys. We've reached the end. I think we have to all go back to our busy lives, but it's always great to see you, and happy Thursday.
Great.
Bye.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the Midas Touch newsletter at MidasTouch.com/newsletter.